Hi, I'm Attorney Samantha Gordon with McIntyre Elder Law. I wanted to discuss today a case study. We currently have a case that's in probate. Probate is the ugly court proceeding where your assets have to go through the court, be approved by the court to actually transfer the assets to your beneficiaries. And because of no estate planning that was in place and improper estate planning that was in place, this is the situation that we're dealing with. So, we have dad, who is James, we have mom, who is Betty, and then we have the kids, Jim and Bob. Jim has no children. Bob has an ex-wife, 2 kids from that marriage, a new wife, and a new minor child. Okay, there's a home. The home was owned by James, dad, Betty, mom, as a married couple, and Bob, one of the children, with his now ex-wife as a married couple. A married couple, when you own a piece of property as a married couple, that means you own the property tenants by the entirety, which means that if something were to happen to James, automatically their share goes to Betty and vice versa. So if you own a property with your spouse, your share automatically upon your death goes to your spouse by virtue of owning it tenants by the entirety. So this is what happened. James passes away. James had a will that left everything to Betty, which was great, but he's the only person in this situation that had estate plan documents. So James passes away. Automatically his share goes to Betty because they own their half tenants by the entirety. And now Bob, his child, and Bob's ex-wife, at the time his wife, own that property. Okay, so what happens is Bob passes away without any estate plan in place. That means no will, no trust, anything. At this point, he was divorced from his ex-wife that he owned this property with, was remarried, and had a minor child, and also 2 adult children from the previous marriage. Okay? So, Bob passes away. What happens when Bob passes away? Well, Bob's ex-wife still owns that property. She still owns her portion. New wife and 2 kids from the previous marriage, minor child and Betty, all own that house now when Bob passes away. How did that happen? The way that happened is Bob's ex-wife, when they got divorced, they never changed this deed, which means that when they got divorced, Bob and his ex-wife owned 50% share. They each owned 25% of that 50%. So when he passed away, his share went to his heirs at law, which was his new wife, his 2 biological children from the previous marriage, and his minor child. His ex-wife still remained an owner of that property, and Betty was now an owner after James passed away. So that's how that happened, because there was no estate planning in place, and his heirs at law, Bob's heirs at law, were his new wife, his 2 kids from a previous marriage, and a minor child. So now you have an ex-wife, a new wife, 2 kids from the previous marriage, a minor child, and Betty all owning this property together. How can a minor child own property? They cannot. So now a guardianship has to be established in order for that minor child to actually have that interest in property or deed over that interest to whoever it's supposed to go to. So now Betty passes away. Betty passes away. Jim, who was the child up here that has no kids, Betty did not have a will, owns that property. Bob's ex-wife, new wife, minor child, and 2 kids from the previous marriage. Now, all of these individuals own that property. Unfortunately, Betty passed away in Virginia. So, what now we have to do is this. We have to open up an estate for James so that title can properly transfer this way, so that there's a chain of title, so that if anyone goes to buy that property, they know how that property passed. James' estate's going to be open. Now we have to also open Bob's estate because we have to transfer the interest that went when Bob passed away to all these individuals. And then also, because Betty passed away in Virginia, we have to now work with a Virginia lawyer to open up an estate for Betty in Virginia so that her share can properly pass to Jim, and all of these individuals can figure out what they want to do with this property, if they want to sell it, whatever. But unfortunately, since we have a minor child that owns that property, we now have to go through the courts in the county where Bob passed away, open up a guardianship for his minor child so that any interest that that child has can be transferred properly through a guardian. So, Now we have an estate open up in Virginia, we have an estate open up where Bob passed away, in the county where he passed away, and we have an estate opened up where James passed away as well. 3 estates, 1, 2, 3, 4, 5, 6 individuals owning this piece of property, all because we did not have proper estate planning in place. This could have totally been avoided. The headache could have been avoided. If your head is spinning, it should be. This could all have been avoided with the proper estate plan in place. And that's why I wanted to jump on here and explain that, because right now we have all these individuals that own this house that's trying to be sold, and nothing can be done. The house cannot be sold. There's not clear title until all of this gets figured out, until all 3 of these estates are handled properly and this interest is properly given to those individuals, and the child has a guardianship established so that a guardian can sign away their interest. So if you have a proper estate plan in place, you can protect your assets, ensure that things pass properly, and hopefully avoid probate, the ugly court proceeding that now all these individuals have to go through because they did not have proper estate planning in place. Give us a call at 888-999-6600, or you can go to our website at mcelderlaw.com/scheduling.
Please don't wait till it's too late.